From the nation's capital, Washington Debates for the 70s, a series of programs designed to bring together for an open exchange of views and opinions outstanding authorities on vital issues facing the world of the 70s. The topic, Watergate and the law. How can we prevent Watergates from happening again? Do we need new laws? Better enforcement of present laws? Is the president too powerful? Now, here is Peter Hackett.
The word Watergate needs no elaboration. Its implications for the American legal system, however, are not quite so clear. While everyone wants to avoid any repetition of the affair, the changes necessary to our political, legal, and institutional arrangements are hardly self-evident. Should law enforcement agencies, for example, become more independent of presidents? How can government become insulated against improper influence? Should there be new curbs on presidential powers? Is it possible to have a truly independent special prosecutor? How closely should government agencies be regulated in such areas as wiretapping? Anticipating such questions, two senior members of the Senate Select Watergate Investigation Committee, Senators Sam Ervin and Howard Baker, asked the American Enterprise Institute to help identify the legislative implications of the hearings held by the committee. The Watergate Committee requested a report on what the committee calls the options or alternatives which might feasibly be open for serious contemplation by the committee, plus the advantages and disadvantages of each option. AEI commissioned a study for this purpose and named a panel of distinguished scholars to serve as consultants. The results of their task include a report by the project director, which has been published by AEI. The project director is Ralph K. Winter, Jr. of the Yale University Law School. Now we come to the second phase of the project, a roundtable discussion of the issues by members of the panel who served as consultants for the project. Taking part in this roundtable discussion of Watergate and the law are Professor Harry H. Wellington of Yale University Law School. Professor Wellington once served as a law clerk to the late Supreme Court Justice Felix Frankfurter and as a senior fellow at the Brookings Institution in Washington. Ralph K. Winter, Jr. is also a professor of law at Yale and is an adjunct scholar at the American Enterprise Institute. Professor Winter has also served as a senior fellow at the Brookings Institution and is a consultant to the Senate Judiciary Subcommittee on Separation of Powers. James Q. Wilson is chairman of the Department of Government and a professor at Harvard University. He's the author of many works, mostly dealing with politics. Richard M. Scammon is director of the Elections Research Center of the Governmental Affairs Institute. Mr. Scammon served as director of the U.S. Bureau of the Census under Presidents Kennedy and Johnson. Moderator of our discussion is Professor Alexander Bickel of Yale University Law School. Professor Bickel, who preceded Professor Wellington as law clerk for the late Supreme Court Justice Frankfurter, is Chancellor Kent Professor of Law at Yale. He serves also as a consultant to the Senate Judiciary Subcommittee on Separation of Powers. Now to moderate our discussion, Yale University Professor Alexander Bickel.
In discussing various specific proposals for reform and change, we will try, I trust, as we did at the first roundtable, not to assume that something must necessarily be done. Reform and change are not self-evidently virtuous aims, and Watergate, although certainly a grave malfunction in the system, may just possibly not have turned up any fundamental defects in it. Law-breaking has always been with us, and it's a fair guess that it will be again. And yet it would be feckless to disregard the fact that Watergate, at the very least, presents an opportune time for re-examination of some of our structures and procedures, and has created a favorable climate for reforms, whether or not those reforms are necessarily related to whatever Watergate as such may have revealed. So the first topic is the functions and powers of the President to guard domestic security against rebellion, terrorism, and the like, and national security against foreign enemies. The issue is really one of emergency powers, which may inhere in the president, to wiretap, for example, and perhaps otherwise to impinge on normal civil rights. Extreme claims have gone so far as to say the president may do virtually anything short of ordering executions. Well, this side of such extreme claims, there is an area, a debatable area, of inherent presidential powers. Now, the centerpiece of our discussion at this roundtable, as at the first one, is the report by Ralph Winter entitled Watergate and the Law. And I will therefore, on this issue as on other ones, call on him to lead us off. Ralph?
Thank you, Alex. I don't know that there is a serious problem as to presidential power where domestic security is involved. That is to say, I'm not convinced that the criminal law, that the operation of the criminal law is not sufficient to protect the nation against whatever dangers there may be. And there certainly is danger in extending presidential power in the area of domestic security, because the principal way of extending it really is to allow all kinds of surveillance and other kinds of activities like wiretapping of people that the executive branch thinks are inclined to break the law. The president may well have extraordinary powers where there's been a complete breakdown of law, but certainly just in the normal situation, all too normal, one might say, of terrorists and the like, I don't think there's any evidence that any changes in existing law are necessary. Where national security is concerned, a lot of people think that presidential power is considerably greater than it is where it's only domestic security. And by national security, I mean where there is foreign involvement. I would think, and I'm prepared to defend the position, that we ought not, through legislation, attempt to restrict the president's power in domestic security beyond the restrictions that are now applied. I think there's a dual danger in that. One is that any restriction is very likely to contain ambiguous language which may, in fact, empower the president to do more than he is presently explicitly empowered to do, rather like the problem that arises in the war power bills. The other is that I don't think there has been sufficient study, and I am not convinced, that the president doesn't need a great deal of flexibility where national security matters are involved. Major governments do engage in various kinds of activities, which are unlike, which go beyond normal law enforcement procedures. Talking about wiretapping of embassies, as an example, without a warrant. I say I don't think that another reason that further restrictions are not necessary is that I rather suspect that once we get 4 years beyond Watergate, or perhaps not even that far, these things are going to happen anyway. That a law that attempts to restrict the president too much will be a law that is broken. It will be a law that is not obeyed. We will get in the habit of not obeying it, and we will find that indeed what we're really afraid of, the abuse of this power, will begin to happen because the law itself is too unreasonable. It seems to me that what we ought to do is somehow impose procedures which elevate, as you've said, the threshold at which the executive branch engages in these activities. We have to increase the political sanction in a way for abuses of this power. And one way of doing this, I think, is to assign explicitly, somehow, assign responsibility for ordering such acts, so that we don't have what appears in the Watergate affair, have a situation in which subordinate members of the executive branch were authorizing things in the name of national security, a situation in which the subordinates may or may not have thought they had authority, a situation in which those higher up may or may not thought they could disavow what was happening. It seems to me you increase the threshold at which the executive will do things when you lodge sole authority for ordering such acts in responsible officials, in the president, where there's wiretapping in the name, because of foreign or military affairs, requiring the signature not only of the Attorney General but of the Secretary of Defense or Secretary of State. In any event, lodging responsibility explicitly in accountable officials, so that we don't encourage abuse by a great deal of confusion as to who has authority to do what.
I might just add, by way of clarification, that until 1972, am I right, the law on the subject was wide open, and the practice of wiretapping, at any rate, breaking and entering, I suppose, quite a different matter, but wiretapping had been pursued in domestic security affairs since the administration of Franklin D. Roosevelt. In 1972, the Supreme Court held that that was unconstitutional without a warrant, although Justice Powell, anyway, suggested that the warrant procedures might be a little different than they are in the normal criminal case, and that Congress might provide for such warrant procedures. The question of whether wiretapping on the President's own authority without a warrant in foreign security cases, national security cases, foreign embassies, whether that's legitimate, whether that's constitutional without a warrant, that's an open question. The court didn't say no, it didn't say yes, and the question is open. I take it that continues, and I take it the domestic wiretapping, which the Nixon administration had engaged in as much as prior administrations, perhaps more, perhaps less, I take it that that stopped. So there is some law on the subject, and there is an opportunity for some statutory intervention if Congress choose to do it. As things now stand, you have to get the same kind of a warrant in a domestic security case as you would in a normal criminal case, which may be a little difficult.
Well, but to get the warrant, you have to show some probable cause for it, some information. The kind of statute that Justice Powell seemed to have been talking about, I would think, is a statute which really it authorizes warrants where the particular officer of the government has a subjective belief that certain people are inclined to violate the law. I mean, it's hard for me to see how one relaxes the procedures without getting to that. And I think belief in inclination is just too flexible.
Well, I'm not advocating that kind of a statute. You'd still have the security of going before a judge, so that the subjective impression of a executive officer would have to run the gauntlet of a federal judge sharing it or not sharing it, saying that this is paranoia or this seems real.
There are various forms of surveillance in the area of domestic security that are not electronic in nature, that involve, for example, the infiltration of extremist groups somehow defined, following, questioning, developing dossiers on them. And I don't think we should leave the discussion on the implicit assumption that the law in this area is clear. As near as I can tell, the law in this area is quite ambiguous, if indeed it exists at all, that the Federal Bureau of Investigation has for many years, and not simply under Mr. Nixon, felt it was its responsibility to maintain fairly close surveillance over groups it defined as extremist in some sense. Now, if you happen to be a member of an extremist group of the left, you are opposed to this until it is pointed out to you that this surveillance is also taking place under the Ku Klux Klan. And I suppose if you're a member of the Ku Klux Klan, you oppose to this until you realize it also takes place with the SDS. I don't think, and I am not a lawyer, a point which I hope to repeat many times this evening.
Matter of real pride, isn't it?
Yes, it is. Thank you. That there is any law, or that the law is sufficiently clear, nor am I certain in my own mind that we know yet how to draft an internal regulation, much less a statute, that would place clear and feasible boundaries around this aspect of investigative authority. And I think we ought to acknowledge the ambiguity of this area, because this is one of the charges that has been leveled at this administration, that it, to an inordinate degree, encouraged the Federal Bureau of Investigation and other agencies to maintain active surveillance, the so-called Nixon memo and other matters.
I agree. There isn't any law on the subject, but I know there was a case in Chicago involving, I believe, a friend of Frank Sinatra's, who was being shadowed by the FBI. Was just following him around. He was a mafia type, and he went to court to get an injunction against the FBI following him around.
Mr. Giancana, yes.
That's the fellow. The thing ended very ambivalently, because it's difficult to find in the Constitution or anywhere, a right of privacy against being observed essentially in public places, which applies also to infiltration of groups. I mean, if you're the Klan or the SDS and you freely recruit people, I don't think the Constitution guarantees you that the people you recruit are there in good faith. They're there because they agree with your objectives. It is, I agree, very difficult to imagine the ground rules that would apply to this, and very difficult to think of a country that has no power to do this.
We do have some law respecting entrapment, for example, which looks in quite a different direction from the law having to do with wiretapping. There's a very substantial amount of power to infiltrate and to engage in entrapment. It's very much the same Supreme Court. It may have been the same year. The Russell case, was that 72? That upheld entrapment.
Well, up to a certain point.
Well, but a very substantial point. Yeah. I was wondering, though, whether...
Perhaps you better explain entrapment, Harry.
Well, I wish I could. But entrapment is typically infiltrating and inducing in some fashion or another someone to commit a crime. It's a fairly technical
like a narcotics sale, for example. You suspect the fellow...
But it could also apply to left-wing groups or right-wing groups. But the question I wanted to return to, I have a great deal of sympathy with Ralph's presentation with respect to the distinction between domestic and foreign security matters. It makes good sense. We can put it, you can write it out, and you can suggest that you should have different bodies of law with respect to one and the other, and one certainly can think of extremes. This is clearly a domestic security problem. This is clearly a foreign security problem. Isn't there a very real difficulty in separating the two? Aren't they very often intertwined in a way that would make it quite difficult to say what was involved?
As in the Ellsberg case, for example, where the claim was that they went after Ellsberg when they thought that he'd delivered a set of these to the Russians.
Set of the Pentagon Papers.
Yeah.
Or the Venceremos Brigade, a group of domestic persons of an extreme political persuasion who nonetheless made a trip to Havana when other Americans had not made the trip. Now, is this domestic or foreign security, or is it security at all? I have a feeling as a political scientist, as a rather lawyer.
Well, you're not a lawyer.
No, I'm not. That
we're not political scientists, by the way.
No. That the Watergate atmosphere might be not very useful time to engage in such legal clarification as might be necessary in this area, because it is a time in which, it seems to me, the perspective necessary to make these judgments may be lost because of the preoccupation with the real or alleged involvement of the present administration in furthering these activities. I happen to think the problem exists without regard to administration, and it might be useful to address the problem at a time when we can abstract it from the nature of the incumbent.
Well, I think that those, all of us in this room, being the calm types that we are and not overtaken by waves of hysteria, I can say a few things, even though none of us is both a political scientist and a lawyer. It does seem to me that the distinction is shadowy, and that's a good thing, and that's a good reason for having the law on the domestic side not loosened, having it rather, keeping it fairly strong, because that increases the political risks to administrations that take actions in the name of national security that may be treated as domestic cases. I would not like to see the law clarified too much, because the clarification may in fact reduce the risk in a way by drawing the line in one place rather than another. What I would like to see is any administration making the judgment, well, we don't want to wind up in court over this, and we will if it's not clearly national security. That's the kind of a system I would like. I think the whole Watergate incident does illustrate this, that the Ellsberg burglary, in fact, was way too far over on the domestic side. And it was the fact that it did get into court that makes the political risk so great.
Not only that, it's always nice to find a silver lining in Watergate, to derive some benefits from it. But I think what Watergate will have done, without the need for any law to express it, is to draw a line between, on the one hand, infiltrating, shadowing, watching, entrapping, things that are done by government, by the FBI or what have you, in public, so to speak, against activities that are themselves public and that have committed themselves into the open, on the one hand, and on the other, wiretapping, let alone breaking and entering, as in the Ellsberg case. Now, we know with reasonable assurance that even though J. Edgar Hoover said no to the Tom Charles Houston plan, the FBI had in the past itself engaged in some breaking and entering. I venture that the line, the bright line between shadowing, entrapping, infiltrating, and breaking and entering is pretty clear now, and clear to the FBI as well, and clear across the board, domestic or foreign. No law is needed, but it's a very good thing for that to have happened.
Well, but I meant to be coming at this from the civil libertarian point of view, and wondering whether perhaps the decision of the Supreme Court requiring a warrant in domestic security perhaps ought not to be extended to cover foreign security matters. The principal argument against it is it's extremely sensitive, and you ought not to involve the court in it. But to the extent that you do involve the court in shadowy areas where the two are intertwined, I wonder how much further we're going, and I wonder whether we might not be able to trust our judges so that we could extend.
Well, I would imagine that foreign security, though, parses out into a number of situations. You have, we all keep thinking of it as placing a tap on the Russian embassy. And, you know, sure, you can trust Judge Sirica with that. But extend it a little farther. It's some CIA or intelligence operation, you know, it's some Ian Fleming plot, or the spy who came in from the cold, and you've got lives in question, and you've got foreign agents here, and so forth. There was a case in the 50s, the Colonel Abel case, the Russian spy, and there's a Supreme Court opinion at great length, which forswears any need for warrants. They broke in on him and searched him without a warrant, and the court says, well, that's a foreign matter. It's a different matter, and one does hesitate when you visualize it that way, as a real intelligence operation rather than tapping the Russian embassy. It does become a little picky to think of a judge passing on that, being given the facts, which is, I think, where the hesitation comes. Of course, the question is open.
Well, and I don't mean to suggest that there is any kind of an easy answer. It's a trade-off, and the question is how we ought to err. And I think I'm inclined to think that perhaps we ought to err more towards requiring a warrant. It might be that we can, with time and experience, have a different kind of, finer kind of distinction than the gross distinction between national security.
It's certainly possible to require them to come in on national security cases as well, to disclose to the judge if they can, and if not, to hand the judge a sealed affidavit saying indicating the reasons why they can't disclose, and asking the judge to issue the warrant on their authority, which is not a wholly unaccustomed thing in the law. That is, instances where judicial power is invoked on the authority of the executive without going to trial about it.
But irrespective of how we go along those lines, Ralph's suggestions in his pamphlet seemed to make very good sense with respect to requiring high-level people. That is, where we're in the area where a warrant isn't necessary, there ought to be clear lines of authority. It ought not to just be done by the Attorney General. It certainly ought not to be done by people in the White House who don't have official positions except at the pleasure of the President.
The question of presidential power and its possible abuses by presidential appointees is not an easy one to solve, nor is the matter of national security when it comes to such things as wiretapping, be it for domestic or for foreign security purposes. Another matter of concern growing out of the Watergate incident has to do with investigations of high-level government abuses. How independent can the Justice Department be? And what should be the role of an independent special prosecutor? Once again, Professor Bickel.
The second topic that we're going to try to deal with this evening relates more immediately to the Watergate experience, and it's the problem of political control by the President, by an administration, which can be exercised or can influence the Department of Justice and the administration of justice. The Department of Justice, of course, part of the executive department. When it comes to prosecuting, for example, close associates of the President himself, as in the current instance, as happened in the Truman administration, as happened in Teapot Dome in the 1920s, this is in this respect not unprecedented. Obviously, questions are raised, at the very least misgivings are legitimately entertained about the administration, in effect, prosecuting itself. And so the questions arise, should we take the Department of Justice, perhaps, out of the executive department, make it independent in some fashion, not subject to control by the President? Or should we perhaps provide ways for appointing special prosecutors, institutionalizing them in some fashion, they also being entirely free and independent of presidential control? Ways of doing that might include setting up an independent prosecutor like that permanently, as a permanent office, or providing standby authority for doing it. Well, these are the issues that we now address ourselves to, and again, I'll start with Ralph, who has something to say about it in his report.
Well, it's always tempting in the wake of an event like Watergate to contemplate separating the Justice Department from the political branches, for saying that the administration of justice cannot be affected by partisan considerations. And I don't mean to say that's not attractive by saying it is attractive. The problem is, the problem is, of course, that the Justice Department also has very, very important policy decisions to be made. It has the allocation of resources, decisions to be made. Should there be more money in LEAA? Should there be more money to prosecute civil rights cases or organized crime? Or should the money go into some other kind of litigation? What cases should be taken to the Supreme Court? What the position of the government ought to be on various constitutional questions? A whole range of questions which I think one would normally want to be resolved by officials who are accountable to the people through the President. One of the things presidents ought to run on. As we get down to individual pieces of litigation, I would suppose the danger of partisan control is greater, and perhaps the need for electoral control is slightly less. I don't mean to say it's not there, but I think that the need for having someone who is a presidential appointee in every case before the Justice Department is somewhat less, although I strongly feel that in as far as settlements and consent decrees and the like are concerned, the basic policies decided upon by the political officers have to be enforced. It does seem to me, though, there are few kinds of cases that come up in which special prosecutors, or what I call special counsel grand juries, would be useful. I don't think the case for a permanent special prosecutor has been made. I think there is a case for provision for district judges to appoint special prosecutors to aid in various investigations. I think where there is a conflict of interest, where high officials of the government are under investigation, or where the opponents of these high officials of governments in previous elections are under investigation, that a special counsel to a grand jury would be very useful. This seems particularly the case since Congress seems in a mood to pass laws regulating elections, to pass laws which greatly increase the chance of a whole range of political trials taking place in the United States in the future. I do not think the special counsel ought to have the power to prosecute. I think that the decision to prosecute should remain in the Department of Justice, that the indictment must be signed, should be signed by the U.S. Attorney, and if the U.S. Attorney declines to sign it, that the judge can make the presentment public to the people. Again, the ultimate decision would be political, subject to political sanctions if the Justice Department decided not to go ahead with a strong case. But there are cases in our recent history, indeed, in which district judges have tried to get the local U.S. attorneys to prosecute civil rights demonstrators and the like, cases in which the Justice Department was clearly right in declining to prosecute. So I think there is a case for a reform here, although I feel the tremor of dissent to my right on the special prosecutor issue, at least.
Well, to say that this is an overreaction to Watergate is to put it mildly, and to say that it's probably unconstitutional is to just add icing to the cake. But I don't want to take up the whole time. I am opposed to the idea. I don't know what our political scientist friends think about it. I'll just suggest to them, because I think this ought to hit a nerve, that at the very least this would establish, whether it's a permanent independent special prosecutor or some nearly 500 district judges all over the country granted the power to appoint them at will, it establishes serious power, major power, no joke, in irresponsible hands, in hands that are accountable to no one. And I should think if there's any single thing about the genius of our government and the fundamental meaning of separation of powers, really, is that there is no such thing. There is no power anywhere in government which is unaccountable to anybody. The judiciary, lifetime tenure, okay, there they are. But otherwise, power is either legislative or executive, and that's not because it's elegant to divide them that way, but because those are two categories of accountability, of power running from whoever exercises it, ultimately to democratic responsibility.
Except in the case of the courts.
Well, yeah.
You eliminate the judicial as a lawmaker, and I would think, Alex, one would have to recognize, particularly in the last decade of actions, that courts quite frequently are willy-nilly placed in the role of making law. And at the federal level, at least, no one has seriously proposed that federal judges be elected for a limited term and then be subject to re-election.
But the critique of judicial activism always is bottomed, in the end, fundamentally, on this proposition. The trouble with judges making law, rather than deciding cases and making whatever law they make only interstitially for the purpose of disposing of that case, the critique of it is that it's irresponsible power.
Let me make the case more strongly. If you look at the behavior of many federal district court judges, you can only conclude that a significant fraction of them have decided to appoint themselves school superintendent, zoning commissioner, health commissioner, advocate, consumer representative, an ecological czar. Now the suggestion is that they in addition appoint themselves district attorney and chief of police. I think that the line could have been drawn back a ways. This is probably a good place as any to dig in your heels, but this does not mean I'm opposed to the idea of a special prosecutor. I think for all the reasons that Ralph Winters indicated, there are circumstances where we have to have a genuinely independent prosecutor. But though I have no particular proposal to make, I'd like to ask Ralph why he did not propose, instead of district judges selecting the prosecutor, some congressional procedure whereby given the consent of both houses, perhaps outside the normal committee structure, since we do not want the committees to become not only investigative bodies but also prosecutive bodies, that the Congress could not, under certain circumstances, as a regular matter, select special prosecutors? Or is that already so well recognized that no special provision is necessary?
I think they can call for the appointment of a special prosecutor. They can pass legislation. I think that becomes too unwieldy. It involves too much political controversy and the like surrounding the investigation. I just prefer a system in which district judges have the power to appoint the special counsel. I would permit the Justice Department to appeal if you want more control over the district judges, and they don't have the power to prosecute. They can run an investigation, and the political sanction will come into play when the presentment is made.
You know what enormous power you lodge in them? The power of sitting there with a grand jury, which of course the prosecutor directs. The grand jury doesn't exist really aside from the prosecutor. He's got the power to subpoena anybody he wants to, investigate anything he wants, harass, pull people in, and then issue a presentment and accuse people in public without the possibility of their defending themselves. It's just an enormous power. People have been hollering and crying about the abuses of grand juries and about the great irresponsible power that they hold for years now. And that was when the grand jury was, after all, a tool of a district attorney or a U.S. attorney who was politically responsible to someone. Now, you would cut that loose and let any district judge anywhere in the country appoint himself a fellow to wield that power. That seems to be an absolute enormity.
Well, Alex, if you think grand juries have too much power, then we ought to be talking about reforming grand juries. I'm talking about...
no, you're talking about giving them more power.
No, I'm not. I'm talking about giving some device to help them operate more effectively. What I'm afraid of, in the other areas we've talked about, we have tried to get some kind of institutional arrangement that would impose a heavy political sanction for those who engage in various abuses. I don't think that sanction is very strong when you are in the pre-investigation stage. I think the possibility of abuse is much greater in the pre-investigation stage than it is as you get further and develop the evidence. You know, the whole way the Watergate situation broke does tend to indicate that, you know, the investigations can be carried on, and it's very hard to carry on an effective investigation of high officials in the government. It's hard for everybody in justice. It's hard for the prosecutors. It's hard for the witnesses. Well, it's hard for everybody.
But I'm not at all sure that the lesson of Watergate, as it will turn out, is that the ad hoc appointment of a special prosecutor by the Attorney General is not a successful device in extraordinary cases. One of my difficulties with the proposal is that I think it works at cross purposes with what I think is an essential reform, and that is the real strengthening of the Justice Department in terms of having as the Attorney General and as the appointed Assistant Attorney Generals and Solicitor General, men of very high quality, of having career members of the Justice Department, lawyers in the Justice Department of very high status in the legal profession. Now, I think that we haven't done enough in that direction. I think part of the fault is in the law schools, really. It's the notion frequently of graduates of law school is maybe I should go to work for a short period of time for the government in the U.S. Attorney's Office or the Justice Department and then get out and go into private practice. I think we ought to pay better for career attorneys. I think we ought to bestow on them status. I think that to have a institutionalized system of special prosecutors must be demoralizing. I would think that an awful lot of very good people would, who might otherwise find as a career the Justice Department, would find it unacceptable under those circumstances.
You know, it can be done. I'll just interrupt for a minute. The Solicitor General's office, for some decades now, has been a career office in which people of high status in the profession serve for years on end, 10, 15 years. Why can't that be done in other parts of the Justice Department?
Well, I think there are some places, certainly Mr. Peterson is an example.
Yeah. There are very few of them.
But it doesn't always happen. It should be encouraged. Certainly the notion of separating the Justice Department off and making it independent, the Irvin proposal seems to me to be unquestionably wrong.
Ludicrous is the word you're searching for.
I want to dissent from the proposition
Not legal jargon.
that it would lower the morale.
I had it, but I just didn't want to use it.
I want to dissent from the proposition that it would lower the morale of professional lawyers in the Justice Department to have this kind of provision around. I think they would like it. I think they would use it. I think it is a way for them to get out from under the very, very tough procedure we now have of filing a piece of paper that's printed in the Code of Federal Regulations saying what a special prosecutor's jurisdiction is, so that the special prosecutor is constantly put at odds with the Justice Department over that jurisdiction and is put in a position where he has to fight it. I think a professionalized staff in the Justice Department would welcome such a proposal rather than have their morale lowered. This is not to say that I don't want a professionalized staff. I mean, I think, well, one thing is you've got to stop appointing campaign managers to the post of Attorney General. You've just got to stop that. Both parties have been doing it. It is a terrible mistake. It's an invitation to trouble because they have too many partisan responsibilities.
We used to make them postmasters general, and you saw what happened. And now we made them...
they couldn't deliver the mail, and
that's
now
right.
we put them in the Justice
Now
Department.
they deliver justice. I want to recur...
They can't deliver the mail either.
I'd like to recur to one point that Harry touched on, which I think deserves emphasis. What is it in the experience of Watergate, corruption scandals in the Harry Truman administration, some scandals in the Eisenhower administration, then back to Teapot Dome. What is it that persuades you that political pressures don't work perfectly well to solve the problem of the Justice Department sort of prosecuting itself? Under Harry Truman, there was an episode with a special prosecutor. He went out, but prosecutions went on very nicely. T. Lamar Caudle served his term in jail, et cetera, et cetera. Teapot Dome, a method for appointing a special prosecutor, two special prosecutors, subject to Senate confirmation, was worked out, and they prosecuted all you want. In this instance, with all the pressures of Watergate, that's the one difficulty that was met. That was met. The special prosecutor's office has worked.
But it also seems to me, Alex, you're adding another point here, which, again, if I may speak for you, what it seems to me you're saying is that the further the actions of government are removed from the electoral control of the people, the more likely they are to ride roughshod over the rights of the people. And the courts at the federal level, not at the state and local level, where you do have, in many cases, elective judges, which is not necessarily a good way to do it, but at least it's different. At the federal level, the life term conferred upon the judge, with removal only under the most heinous of circumstances, does inevitably lead to a certain distance from the people. Now, perhaps in the administration of justice this is wise, but I can see your point entirely that sort of equipping each judge with an extra duty mace, which is what you seem to be regarding the special prosecutor as, would have consequences that Ralph wouldn't agree with, but seem to be...
No, wait a second.
Political control. Suppose a special prosecutor... Wait a minute. Suppose a special prosecutor had been appointed... Suppose a special prosecutor had been appointed, as he undoubtedly would have been if this were on the books, during the McCarthy era, when Joe McCarthy was saying the Truman administration is full of spies, the president isn't prosecuting them, they're his own people, Alger Hiss is Dean Acheson's friend, this is all one circle there, and he's not cleaning them out. So we need a special prosecutor to get in there. And so Otto Otepka or somebody gets appointed special prosecutor until he finishes the case. he'd be there prosecuting red spies today. Because the mood has changed, the politics of the country, but he's independent of it, and he's going out there after spies. He'd be doing it today.
Well, in defense of Ralph.
Gee, I wouldn't mind if you guys let me defend myself. Well, go ahead, Harry.
It might be possible, but what was not undertaken here, and quite appropriately not undertaken in
Any
Ralph's
serious
paper,
analysis of this proposal?
what was not undertaken was the drafting of the statute. Now, it might well be that some of the, if I may say so, exaggerated consequences.
You may say so.
Might be cured were you to put your mind to drafting the statute. I don't mean to suggest that on balance I think it's a good idea, but I think that it's something to be considered and examined. Someone might sit down and try to write a statute dealing with. We might just say a word about the Constitution.
Yes, I was going to say, I don't want to bore you with legal technicalities, but there are serious constitutional problems.
Right, and that might be a reason for rejecting it, because I share what I take it you and Ralph and even political scientists probably believe that there is some obligation for the legislature to consider constitutional questions, and if on prudential issues the balance is not all that clear in one direction, they might stay their hand if they think it raises a serious constitutional question.
And the serious constitutional question, in a nutshell, is what is assumed away by Ralph, namely whether prosecution is an executive or judicial function.
Who is this Ralph we keep talking about? Is there such a person?
A man named Winter. He's a sunshine soldier.
He's alive and well somewhere. If I may now, Alex, if I may assume you...
Yesterday, you would have gotten a lot of trouble, too.
If I may assume you away for a minute. First of all, I think there's more. There's abundant authority to appoint a special prosecutor, and there is the provision in the Constitution saying that Congress may empower courts to appoint various federal officers.
Secretary of State.
As I say, as you know, I say in the pamphlet that they can't do that, but they can appoint officers.
Judicial officers.
Connected with the judicial
function.
That's the
question.
This is connected with the judicial function. He
That's
has only investigative power. He does not have the power to prosecute.
The investigative power is not a judicial power.
Nor do I see, Alex, why it is this particular power cannot be surrounded by safeguards like a requirement of finding a probable cause or other things like that. I think it's ridiculous to say there are going to be 500 special prosecutors. Every district judge is going to have his own.
No, there are going to be more than 500 because the number of district judges is rising.
I think probably Alex
There are going to be many more. But you see how you beg the question. Sure, if this is a judicial, if investigation...
I wish I had a chance to beg the question.
You wrote the book. If it were true that investigation and prosecution is a judicial function, then I agree. The Constitution does say Congress may empower the courts to make appointments. I would read that as limited by judicial or near judicial functions, although some cases have mistakenly gone farther, and that would be fine. But the gut issue is whether prosecution and investigation is a judicial function. You argue beautifully in arguing against an independent Department of Justice that investigation and prosecution are executive functions. I think that's true, and I think that's constitutionally true, and I think, therefore, there would be the most serious constitutional problem.
Where does the SEC or the NLRB get its power to investigate? They're independent. They're not controlled by the executive branch. Well, and your argument is against all the administrative agencies. Wipe them out.
No.
Not that that's such a bad argument.
Well, that's the scenic route of last night. The place of the administrative agency in the constitutional scheme, while somewhat dubious to begin with, is not what you would propose for these special prosecutors. These are fellows appointed by the president. They're confirmed by the Senate. They exercise quasi-judicial functions in one part of them, which makes them judges. And you can appoint judges and call them SEC commissioners, or you can appoint judges and call them judges.
The SEC is a lot to do about prosecuting people.
They exercise, on the other hand, some prosecutorial functions. In some administrative agencies, that's separated out. And strong arguments have been made that it ought to be separated out in all of them, and it's a mistake to meld them. And they exercise in other portions what are viewed as legislative functions, as filling in details by delegation from Congress of legislation and administering the legislation. Now, people had a lot of trouble with that when it was first set up 100 years ago, and one might want to rethink that. It's too late to rethink that, but it's certainly no argument, no handle for you to leap from the SEC to the different and aggravated constitutional monstrosity of the prosecutors appointed by Judge Harold Cox and Gerhard Gesell.
It seems to me that the SEC, having the power, as you describe it, to act as a judge, to act as a prosecutor, to act as a legislator, that power is a far greater offense against your view of the Constitution than the kinds of very limited proposal I've made. They don't even have the power to prosecute, the special counsel I'm talking about. And I ought to say, Alex, that as you well know, and have not revealed to the audience, thereby violating the Security and Exchange Act of 1935, the state practice there's a long historical background of special.
Oh, well, states do all kinds of things. States do all kinds of things. They mix all kinds of powers. I don't think the law of Connecticut binds the U.S. Constitution. But at the very least, there's a serious constitutional problem. It ought to give Congress pause, and it ought at least to give them sufficient pause to consider the equally serious policy and prudential questions that have been raised by everybody else against your isolated position.
That merely shows who was the true reformer on the Yale Law faculty.
If I have time, Mr. Chairman, could I emphasize one aspect of the consideration of the Justice Department that I think perhaps not my fellow panelists, but many people have misunderstood, and that is that in thinking about the Justice Department, we often see areas of success where in fact they are weaknesses or failure, and areas of failure where in fact there are strengths. I think it's much easier for the layman to draw erroneous conclusions about Watergate with respect to the Justice Department than other areas, because it's a complex organization with, to be charitable, rather obscure functions in the layman's mind. For example, many people think that the system of United States attorneys is a good idea because one of them indicted Mr. Mitchell and Mr. Stans and Mr. Vesco. I happen to think that that's not a revelation of the strength of the system, but an accidental feature of a system that is on the whole rather bad. We do not have as Mr. Wellington said, perhaps not referring to this group, a serious professional development of trained lawyers in capacities as U.S. attorneys and assistant U.S. attorneys. What we have is a group of men who work for United States senators. They don't work for the president, they don't work for the attorney general. Others may conclude that the Justice Department mismanages the antitrust division because antitrust prosecution is a perpetual motion machine, or something you can wind up and put on a track and it goes around automatically. The most important economic and political judgments have to be made about what is the kind of case you want to prosecute. It seems to me that the intervention of the President and the Attorney General in the ITT case is entirely correct in a legal sense. That is to say, they have every right to raise serious political and economic questions, especially economic questions, as to whether breaking up ITT makes any sense or not. But whether they do it out of proper or improper motives is an important question. But in much of the popular discussion, you hear the impression that what we need is an automatic Justice Department, a little Lionel train that goes around on a track, and that it prosecutes every conspiracy to restrain trade, and it prosecutes every organized crime racketeer, and arrests every heroin dealer. And that is not at all the way the system can work or should work. And it really is that, as much as anything, that leads me to believe that not only the notion of an independent Justice Department is wrong, but the notion that the Justice Department, as now organized and managed, to refer back to Mr. Wellington's point, is one of the strengths of the system as we've now seen it, and all we need to do is insulate it from political intervention.
Well, I think Harry was saying that we need to raise its professional standards. What has been the matter with political managers coming in, with the sole exception of Robert Kennedy in that respect, coming into the headship of the Justice Department, is that they haven't brought in good people. They've brought in at the sub-cabinet level, with exceptions, politicians and not professionals, certainly not people with standing in the profession, and that's bad, and has no, is not to say that the Justice Department ought to be outside of political control. Of course it has to be. In fact, it's one of the difficulties with Ralph's proposal, because even the kind of case that he would give to a special prosecutor raises issues of the same sort, which are political issues. For example, the Agnew case. Now,
Nothing I can do short of streaking will get attention away from I will draw the line.
Well, the Agnew case would be a typical special prosecutor case, wouldn't it be?
Yes.
Here's and yet, a political judgment had to be made. I think the correct one was made in the end, but one can't think that it could have been made without political responsibility, namely, to take a plea bargain from him, to allow him to resign. These are things that can't conceivably be done and oughtn't to be done by anybody who has no connection to political responsibility, who's not answerable to anybody, who is in turn answerable to the people. It's just inconceivable. I think it's certainly true that if you let things go as they are, you expect in situations of this sort an administration to prosecute itself. There's no, as the president demonstrated when he fired Cox, and as he could demonstrate by firing Jaworski if he took that political risk, there's no way to run the thing within the executive department outside his control. But for God's sakes, I think it's been demonstrated where the countervailing power is and how effective it can be. Namely, it's in Congress. He does enough of that, and he runs the risk of impeachment. Harry Truman fired Newbold Morris, but he didn't go so far as to try to quash the prosecution of the people who'd done wrong. And if he had, he would have been impeached, or he would have had at least a Senate Select Committee on his back.
This roundtable discussion has brought you the views of 5 knowledgeable experts who hold differing opinions on the basic causes and possible cures for the American political spectacular called Watergate. It is the aim of the American Enterprise Institute to illuminate the issues of the day by presenting many such viewpoints, in the hope that by so doing, those in the decision-making positions will benefit from such a free exchange of informed and enlightened opinion. This is Peter Hackus in Washington.
Washington Debates for the 70s is created and supplied to this station as a public service by the American Enterprise Institute, Washington, D.C.